Nsem-Pii TV nie.
Lawyer Nana Aje Bafuwa Adinkomobi efa the removal of Chief Justice Gertrude Alabasachi Torkornoo a hobe hiya se sansem no bete. Na wone Samson Lardy edidi san komono na wo mo kire Granswa John Dramani Mahama ne committee ni gina so na wo mode apam Madam Torkornoo na wo masan apam no say wonye judge of the Supreme Court to be na ni benefit ya waya juma for 31 good years yes and kanesaka no ni nyina no wo mu atimu atwam na ensem a lawyer na naje Bafuwa bisa no edoso na ne nsem a wakagu ho no abusua emodu ye pa mesro se wobenya wotre na mede wako na sansem ni nyina watimu akakote wose wo bisa se eba ne sen anade enti ena se na wo mu epre committee no na wo mu pre akwahen wose financial misconduct no Madam Torkornoo ewo access to Ghana's public fund and I said Ghana be a sika no and Supreme Court and Judicial no wo mo sika mo de bo mo ho bra no Madam Torkornoo ono ni nipa sika no egu ni chen ana wo se biem eba ne sen and a transfer of case atim ababaye sobo a yedi bo bi na yetim di ayi obi adi awusia ensem a lawyer na naje Bafuwa woni news far panyini and I say host Samson Lardy episode de edoso pa na mamene wonko na sansam na wokan ye no na adusua de obo mu suche bibia no kona Koko TV ne ba Nsem-Pii TV ye ne atifo ebeto aso.
Just to clear this quickly before we continue with the substance of the grounds of stated misbehavior and how they have and what they have ended in against what Justice Akufo has been saying. Now, Nanaje, so what would have been your preference? And is there an injustice or is there an unfairness that has been done as a result of this approach? First, not waiting to receive the written address, as it were, the final arguments of the respondent, the Chief Justice's lawyers, to factor it in their decision making, regardless of the fact that they didn't meet the deadline. But a day before, as Aikutu says, they wrote to the committee to say, we are unable to meet the deadline. Can you give us extra time? And we all do this in the courtroom, right?
Yes, my brother. Thank you very much. But I want to confirm one thing. Where was the committee given a timeline within which to operate? Can we confirm that?
We don't know about that, and generally Article 146 does not provide timelines. Perhaps that is the reason when you were passing the Special Office of Special Prosecutor Act in 2017, you put in there that there should be timelines, so everything is time bound.
So, in the absence of timelines, what was the committee in a hurry for? Why the rush? Particularly because you have two other petitions, so to speak, quote unquote, our address all those pending before you. Why? Who was putting pressure on you to achieve what? When you are dealing with a matter as important as the removal of the Chief Justice of the Republic of the land. Why were you in a hurry to present your report on just one of the petitions, right? Which, in your view, will then dispose of all the matters and will make other petitions redundant? Wouldn't you have taken your time to receive the address or submission of the Chief Justice? Doesn't fairness dictate it? I thought that this is not a commission of inquiry, right? It's also not, even though you are using CI 47, even with CI 47, Samson, how many times doesn't the court adjourn just to take our addresses? The court adjourns on many occasions. Sometimes, even when the court has fixed the date for parties to file their addresses. You can come in with an application that may impact the filing of the address. And so the court, in hearing the application or having disposed of the application, will give a new date to the address. And so even under the CI 47, there is always enough room for the court to entertain such request for adjournment to receive or to file addresses.
But that's obviously discretionary, right?
Yes, but I would think that when you are dealing with a matter of this nature, you should be predisposed to a lot of laxity to accommodate, the Chief Justice, particularly given the sensitivity of the matter that we were dealing with, the sensitive nature of the matter which they were dealing with.
You think 6 months, we've been at it for almost 6 months now, is it? You think that's too short when you say they are in a hurry?
I haven't said that the time is too short or too long. I'm saying that in the specific reference to the reception of the address, if a request that comes and is unreasonable, particularly given the feedback that we have received from Mr. Ayikwo, right? To rush to file, to present your report, for me, is very, very, very unfortunate.
What would you say to those who say, well, if you take the issue or your case as seriously as you ought to, you shouldn't be found wanting, to meet a deadline. You should actually work to beat the deadline.
However, given the gamut of evidence that have been disclosed, to have been produced before the committee, given the number of witnesses, I think that it will be. It's not something which is not expected. It's expected that lawyers or barristers will always ask for extension of time in the circumstance of this nature, particularly also given the grievous nature of the matter at hand. Look, this is a matter involving the removal of the Chief Justice.
In fact, the committee said that they received about 10,000 pages of documentary exhibits from both sides.
So, if somebody asks for extension of time, I don't think it is out of place. But
does it also matter, or it doesn't matter to you, that when you file such addresses, according to law, this is actually not mandatory, and whatever you put in the address is not also binding on the judges?
It aids the court in coming to its decision.
That's right.
And if it was not necessary, we would have scrapped it. It is put there to tell you that if you don't file, the court can go ahead to make a decision. However, given the controversial nature of this matter, we want to put it beyond reproach, beyond blemish. As it stands now, it's one of the things that we are going to point to as contributing to the injustice or the unfairness of the process. Look, my brother, the other issue that you raised pertaining to why the committee presented a report on one of the petitions instead of completing with the hearing in respect of the two other petitions. In my view, the failure to do that has not only rendered an unfairness or injustice to the parties that filed the petition, but the Chief Justice, because those allegations will continue to hang around her neck without having the opportunity to prove that they were not true. And so this approach by the committee has also unfairly versed the...
So a very quick one before I go to my Mensa Bonsu. Yes, they had 13 witnesses for one side, 12 witnesses for the other side. They had 10,000 documentary exhibits all together, which makes it a lot. I can't imagine myself as a lawyer having to go through such load to write, an address. But some will argue that sometimes you and I know by our practice, as the case is going on, you should be gathering your address. You will be getting each of the record of proceedings. After the close of each day, you get a record, and then you start writing bit by bit and so on and so forth. But my substantive question is this. How do these two events, not waiting or granting an extension of time to receive the address, to use it to factor into their decision, and also presenting a separate decision, how do these change call them the admitted facts? So that, for example, on the travel expense, the Chief Justice does not deny that this happened, that she took the money, that she went with the husband, that she went with the daughter, and that per diems were paid, and that she retired unimpressed of 6,000 plus or so. If the decision is that this was wrong, this was unlawful, this was unconstitutional, how does giving extra time or presenting a composite report change it?
Whether or not it is wrong would also is one level, and it is distinct from whether or not it meets the constitutional threshold for the removal of the CJ under Article 1461 of the Constitution. They are two distinct. We need to appreciate that not every error or, if you like, offense or happening may meet that constitutional threshold. Otherwise, every flimsy thing may lead to the removal of this Chief Justice. You see, this whole matter, we are talking about, I hear Oliver make reference to petition. This is where the error started from. The error started from the wrong foundation. The president receives a petition.
Okay, please on the conclusions, the substance that have led to the removal of the CJ. And do you also join that? What's your take on the conclusions, the substance that have led to the removal of the CJ? And do you also join that argument that he's removed as CJ but not as a justice of the Supreme Court, as a letter from the presidency said, remove from both, and some have indicted that?
Samson, standards are predetermined. They are not ad hoc. And so if we are going to hold our Chief Justice and justices of the Superior Court to standards, there should be a set standard which are predetermined or predefined. Samson, what is stated misbehavior is still not known.
If you look,
here is the case where I think that my colleagues have been confusing embezzlement and so on and so forth. How do you say this is embezzlement? In the case where the Chief Justice is not a spending officer, there's a procedure. She herself has to apply for funds to be disbursed to her. There's a procedure by which that application goes to. The people in the chain, right, have responded to audit query, and the auditors found the explanation acceptable. How do you call this embezzlement? By no stretch of imagination, you can't call this embezzlement. In any event, what is the procedure for determining impropriety of expenditure in the public sector? That procedure is the audit by the Auditor General. And the Auditor General found no wrong with this subsequent to the management explanation to the queries that were raised. And so where is the wrongdoing? What is the basis for this? In Brightfield versus NTHC, it is clear, the law is clear. When an enactment makes provision for a procedure for taking a step, it is that procedure alone which should be complied with. And in the public space, it is the Auditor General whose work it is to establish propriety or otherwise of an expenditure. And so where is the wrongdoing? How does she commit an error for applying and going through procedure to obtain expenses? I think that the decision is so embarrassing, to say the least. And so, yes, let's hold our public office holders, let's hold our judges, let's hold our Chief Justice to a higher standard, but the standard ought to be defined. Now, in the case of the transfer, how do you say that a Chief Justice who has been given the discretion under our law to transfer cases, to allocate cases, to assign cases to a judge, commits an offense for doing so? How? And then you say that, look, I'm not surprised that they said that the transfer of the staff of the Judicial Service is contrary to Article 296, clause A and B. Because they can't even point to an established regulation that frowns on the transfer. In the absence of a regulation that frowns on the transfer, how do you say that the exercise of that power is arbitrary, is unfair, is capricious?
They find, what shall I say? They don't say the mere transfer or the mere assignment. For example, when they brought in the petitioner himself and the cases he was involved in, you know, at a point, the petitioner had got the Supreme Court to prohibit, you know, Justice Torkornoo, who was not a Supreme Court judge then, to prohibit her from handling the petitioner's case. And then she becomes Chief Justice and still has to do the assignment because that's her job. And she does them, and they say that they find ways to say that the way she did the assignment is like she looked for favorable judges who will give judgments the way she had also done against the petitioner. You know, that's how they weave it around.
The findings of the committee is even an affront to judicial independence. The independence of judges to determine cases outside of any influence. So when the CJ assigns a case to a judge, because of the independence nature of the judiciary, right, is expected to determine the case pursuant to his judicial oath without any influence or, you know, any sort of pressure. And so if we don't have such confidence in judges and think that they can all be influenced, then where do we find ourselves? So the finding itself is an affront to judicial independence.
Okay, so now we have to be sure if there's a particular finding about this, about transfer of cases and assignment of cases, like Aikoto had cautioned earlier. But you see, as I sit here, I'm asking myself, I was asking Inus Ofuseni questions, and she was nodding in agreement and speaking in agreement that, you know, the way sh0cks process went. Do you remember how they vehemently protested, you know, that process? But now, because it has happened the other way, we can use that to rationalize what has happened to the CJ.
Look, you see, I wouldn't want to do false equivalence. I don't want to do false equivalence. If sh0cks was wrong yesterday, it doesn't make what the CJ has gone through right. We have to be careful. If it is scores they are settling, because they keep making reference to sh0cks, if it is scores, let everybody know that we are settling scores. It looks like that is what they want to do. If it is scores that the MPP did it to sh0cks, so we also want to do it to the Chief Justice, then we know it is score settling. But Samson, I don't want to engage in score settling.
Okay.
Samson, I want us to move on as a country where our democracy becomes stronger. Right? You see, everything points to the fact that what has happened is wrong. Mr. Ayukoyotu, my honorable senior, pointed to evidence that shows that the allegations have already been dealt with by the Auditor General in respect of the financial impropriety. Deliberately, they keep making reference to embezzlement. This cannot be embezzlement.
I don't think embezzlement is the word that has featured anywhere. It's financial impropriety. It's financial impropriety.
With the greatest respect, I use embezzlement as an example of criminal offences that proceed from financial misappropriation.
Okay. Thank you.
Then you compared apples with oranges. I'm saying that this is financial impropriety. This is financial impropriety.
Absolutely.
And the Auditor General is the institution, the Auditor General is the person mandated to deal with it. The Auditor General has dealt with it. Can this be a ground for the removal of the Chief Justice? Is the committee an audit committee? In any event, the committee, look, I agree with Mr.
So the committee didn't seek to do an audit. What they sought to do was to understand the policy that was relied on.
The interruption has not allowed me to flow, and I don't think you've been fair to me in that regard. Please, let me put that on record.
I think when you misquote me and misassign things to me, I'm entitled to correct it. I did not accuse the CJ of embezzlement. I did not accuse the CJ of embezzlement. In response to a question whether she was a judge, and I merely said ordinary citizens may be brought before the Supreme Court for embezzlement. I did not say the CJ had embezzlement.
The president's power